The driver's license division process. Once you're arrested for DUI, how does that affect your driver's license? First of all, in the state of Utah, if you've been arrested for DUI, the officer should issue to you what is referred to as a DUI summons and citation. Sort of a white carbon sheet of paper that lists the charges, your information, and serves as your temporary driving permit for a period of 30 days. That driving permit should be issued in every single case for 30 days unless for some other reason your driving privileges were suspended prior to your DUI arrest. This is a document that's going to be filled out and provided to you by the arresting officer at the time of your arrest. Once you've been cited for DUI, you have 10 calendar days from the date of arrest to submit a written request for hearing to the driver's license division. Information on how and where to send that request is included on your DUI summons and citation. If you don't have your DUI summons and citation, you can find information on how to send in the request through the Department of Public Safety's website or on our website at www.utah.DUIDefenders.com. Or you can contact our office and we'll be happy to send that in for you at 801-579-0600. Once you've requested a driver's license hearing, the wheels are set in motion to schedule the administrative driver's license hearing. Just like you have 10 days to submit your request for hearing, the arresting officer has 10 days to submit his sworn DUI report. Once the driver's license division has received both your request and the officer's report, they will schedule an administrative driver's license hearing before an administrative hearing officer. By law, that hearing has to be held within 29 calendar days of the date of your arrest. The process at that hearing involves you, your attorney if you hire one, the arresting officer, and the hearing officer. This is not in a courtroom. The hearing officer is not a judge, is not a lawyer. They are simply an administrative hearing officer employed by the driver's license division. These hearings are informal administrative proceedings, which means the rules of evidence are not applicable. The rules that protect criminal defendants involving Fourth Amendment, Fifth Amendment are not applicable. So it follows a little bit different standard. So having a knowledgeable and skilled defense attorney is very important to whether or not you're going to stand a chance of winning that driver's license hearing. Once the hearing is held, the hearing can be held in many ways. First of all, the parties are allowed to appear in person. If the parties cannot appear in person, they are also allowed to appear telephonically. That means the client can appear telephonically, the police officer can appear telephonically, the attorney can appear telephonically, and even witnesses can appear and give testimony telephonically. The primary issues to be addressed at your driver's license hearing are: 1, did the officer have reasonable grounds to place you under arrest for DUI? 2, did the officer request a chemical test, and did he follow proper procedures in requesting a chemical test? 3, did you or did you not in fact take a chemical test? 4, what are the results of those tests? And 5, procedural issues such as, did the officer provide you with proper notice? Did the officer provide you with a copy of the citation? Those are the issues that the hearing officer will be concerned about when hearing evidence from both you, from the police officer, as well as any other witnesses that may be called to testify. The general process at an administrative hearing is the police officer is first given an opportunity to tell his side of the story. Once the officer has provided evidence, then the defense attorney or the defendant has the opportunity to cross-examine that officer. Once that officer has been cross-examined, then the driver or the defense attorney can provide their own evidence in the form of testimony from the driver or from witnesses, documents such as medical records, test results, or any other information that they seek to introduce. At the conclusion of the hearing, the parties will be allowed to make a closing statement supporting their position and their side of the story. Once the hearing has been concluded, then the hearing officer will take the matter under advisement, review all the evidence, and prepare what's called the findings and recommendations to the director. That is then sent to the main office of the DMV in West Valley City at the Cal Rampton building, where it is reviewed by a supervisor. The supervisor reviews the recommendations and issues the final ruling, which is sent to both the driver as well as to your attorney in the form of a letter in approximately 7 to 10 business days.